Right, this is CR 201702986, August 17th, 2022 after lunch. And Ms. Hessel, I believe that you were I put you under oath before, correct?
Yes, sir.
And you continue to be under oath?
Okay.
All right, so I wanted to sort of start in the questioning to go over dealing with the exhibits, including I think that there are some based on your decision to withdraw part of a case that you're willing to withdraw. But first going to, I don't know how you're looking at things, but could you go to complaints exhibit number 8, debate stamp 082?
Your Honor, may I say something, if you don't mind, before we start?
Sure.
You stated that the second complaint was filed on October 13th, 2017, but I'm looking at the ERD's investigators report. The first contact we made with the division was October 13th, 2017, but the complaint was filed on November 22nd, 2017.
Okay, well, I just go and check.
Thank you.
I believe I said um, October 13th, 2017, and that's what we have.
That's when I received it from your attorney, Dr. Hassel. Now, granted, at the time he had it as an amended
Correct.
complaint to the first one, and then later it got bifurcated into its own.
But it was, and the thing is that you are correct that that's when we received it, but it was served on, it was, served on 11/22 17. And so if there was anything between October 13th and, if we're dealing with a question of what occurred after the filing of complaints, that the date is better, the November 22nd date. I don't think we've had anything in that matter, but that is as far as when the complaint was filed, then that would be the better date to sort of cut off what the date, thing contains. So we do have that period of time that can be in something, but I don't think I haven't heard anything occurring in that period of time, but it's noted what you just said. So
Well, you excluded, I believe you were referencing the October 13th, like Ms. Herzog just said, it was a continuation of the first, so we were just providing updates. And then my attorneys were told that they needed to submit a complaint, a formal complaint, a second complaint. So like Ms.
yeah,
Herzog just said,
right, because it's not an amendment dealing with the situation, and also just simply to note that a couple of things. The put it in as that date of the complaint for the sake of timeliness purposes, so it's to your benefit, and also in the matter that you obviously can't, at least to me, logically, a complaint cannot include an allegation of retaliation for filing itself. A retaliation, you can't, when you're alleging discrimination because a complaint was filed, that requires a new complaint. It is inconsistent or illogical to have in the same complaint.
right, but you're making decisions. You just said you said earlier that the IRB letter of noncompliance was not alleged, but I believe it was alleged in the official complaint that was received in November.
It was, no, I was looking at the November, the the complaint that was received on October 13th did not include any reference to what is in this hearing. That's all in the, I was looking at the amended complaint. So no, what I was referring to when I was looking at was the complaint as served in November.
Okay. I also wanted to point out that you've been saying that the respondent is the Helen Bader School Social Welfare, but the respondent, I mean, it's even on the ERD's statement here, it says respondent is a four-year educational institution with the University of Wisconsin system. So the respondent is
Okay.
UWM.
I'm not, well, I have made a ruling on that already in the situation, and I'm not going over the rulings.
Okay.
That, and I just want to check further here. And note just for the situation that the copy that was served was signed, it says it was signed in October by your attorney at the time and was received on October 13th, but it just wasn't served until November. If we had any issues regarding that situation, then there are a variety of different ways they could be due, but I don't remember there being anything particular that occurred in that month. But then going back to, and I just would indicate, I understand that there's a whole lot of things that my rulings that you disagree with, but that all of them are subject to review. But after my rulings, we need to go forward.
Okay, thank you.
Not go over again things which I've already ruled on.
Okay.
Okay, so, and I'm trying to, in the matter to, I have to put so many things on my screen here to try to get up. Okay. All right. So first we're dealing with the, and I'm not sure how you're looking at documents, but you need to go to, again, it's complaints 8. Okay, you there?
Yes, I'm looking at my list and I do have it, the PDF pulled up.
Okay.
It's a summary
So
of
what?
Go ahead.
And dealing with just a second while I get there. Right, and dealing with all right, now this template, when did you first receive this?
When I
Or
was hired in 2004.
okay, and was this to your knowledge something that was still in use? I mean, did you ever fill that one out this way?
Yes, I've filled this out every year since I've been employed at UWM.
Okay, and it's been the same form?
Yes, sir.
Okay, based on that, is there any objection to admission?
I just wanted to be certain. So this form is not changed at all. As of 2016, you were asked to fill out this form.
Yes. For
Oh.
all of our, so in 26, yes. So
Okay, just leave it
I just
there.
want to confirm. So
asking-
this form you filled out in 2016.
I can't recall exactly if I filled it out in 2016, but we annually report our activities, and this is the form we use to report our activities.
So you're not sure though if it was this form in 2016?
Well, and dealing with the question, just dealing with it, she has answered that and for your cross. Do you have any objection to receipt of this?
Yeah, I still object to it on foundation because I don't know that it's and relevance, actually, because I don't know that it was relevant to the time period in question.
My understanding, and I'll receive it, my understanding is that it goes to what her understanding, I mean, there's two things. One, she claims she was given it and that this form really like it was something that she filled out every year. It says something about, what the job is perceived as being and what questions, the nature of the job. So I'll view it as admissible. Okay, now go to complaints exhibit number 9. And what is this?
This is the divisional template for a curriculum vitae that every faculty member who's going up for tenure and or promotion, submits to the division. So this, we put
Okay.
our promotional, all of our activities, we use this template for all tenure and promotional processes.
What I'm looking at is something different.
Okay.
I'm looking at the procedures and evaluative criteria, which is complaints 9.
Yes, at the end of it, you'll see a template. And so that template is what we use. The divisional.
Okay, well, let me just deal with the first part.
Okay.
Let me see if I make sure that I do have a template at the end of it.
Okay.
I don't see what I would understand to be a template.
Okay, I'll find it for
It
you.
does. No, I mean, there's 3 appendixes: a suggested letter, a list of a format for the Vita, and then there's I mean, my understanding is a template is something that you fill in.
So this
There
is
is also a checklist. So
this is the format. I'm calling it. I'm
okay,
sorry.
but my understanding, and just in dealing with what this thing is, the correct that the appendixes after what is titled the procedures and evaluative criteria, there's 3 appendixes: one a checklist, one a format for Vita, and then there's a suggested letter, and and those are what I'm just talking about, the document at this point. That's what the document is, right?
Yes, sir. That's correct.
Okay, so then because but the thing is in the matter is that this says 2021, right?
Yes, but it also, go ahead, sir.
In the situation as to, was there one like this that was in effect in 2017?
Yes, if you look at page 102, it says editorially revised May 2017. So substantively, there were no changes.
Okay, so you're saying that based on that, I saw that page, and I'm getting to it, that well, I'm seeing that there's a since then, we have 2 editorial revised and a reaffirmed. But that you're saying that that shows that it hasn't been materially revised since May of 2011, right?
Yes, sir.
Okay, based on that, again, that this is going, it's, peripheral to these, but certainly in the matter of the issues regarding understanding what the job is and how it relates to outside activities, that these things go to that. Based on that indication in this document that it was not materially revised since May of 2011, do you have any objection, Ms. Herzog, to admission?
I would only object to the extent that I would like to reserve an objection if I discover that there were material revisions that relate to this case since that time.
Well, I mean, the thing is, the
Like
matter is that I'll allow in dealing with that request, but since the whole document, which I don't have any indication not to accept, is indicating, and then also that this is this issue regarding these cases is fairly peripheral anyway. So I'm admitting it just as it is. It seems to establish its own foundation and clarify. I mean, that's a pretty extensive EID 102 is a pretty extensive and detailed indication of its revisions. So there's no indication to indicate that it's something other than what it claims to be. All right, then dealing with the dealing with complaints exhibit C10, and that do we have a statement and the connection, and what is your position regarding admission of EID 103?
So just to clarify, when we talk about 103, we're talking about just this page, not the video
Right.
itself.
Correct.
Yeah, at this point that I would object on relevance because it's
And it involves hearsay
statement.
statements. I will not receive it.
You will
It's
not
just
receive the link, Your Honor?
No, I won't receive the link or the page because the thing is that it was put in. My understanding is that it's a separate exhibit that the document is. This page is not have any evidentiary value. So, and includes that what you wrote on it was hearsay. Okay, so then we deal with go to page 114.
This one I object because significant changes have been made to this document between the period in question and 2021.
Actually.
May I make an argument, Your Honor?
Just a minute here.
Yes, sir.
I'm still dealing with the I was trying to use the previous, the initial thing in my, the bait stamp number somehow disappeared. And anyway, technical difficulties here. Okay, so in dealing with I thought that, oh, okay. So this is a document dated August 23rd, 2021, and regarding program evaluation and research documents. And the thing is that claim is that there's significant changes. Now you can reply.
Thank you. The Code of Federal Regulations, Title 45, Part 46, which is the federal law governing IRBs, has not changed its conceptualization of what is an evaluation and what is a research. So what is an evaluation and what is research? That's what this document is explaining.
Okay, but the thing is regarding the document and the things that what I'm explaining is this, if this is a different, it's hearsay for the truth in the matter, and I'm not going into those two things anyway, or trying to decide what this has to do with the relevancy of this document. If this is a document prepared 4 years later and the situation is different than was in fact in place, then it's not admissible. So my understanding is you're not claiming, you're offering this only for the truth that this, you're claiming establishes what is the distinction under federal law. Is that what you're offering this for?
Yes, sir.
Okay, and dealing with that, that's not, you know, there is, I will not receive it. First of all, you need more things like learned treatise or something else in the circumstances to deal with kind of providing expert testimony on this difference. And my understanding is that the issue for me anyway is not in the interpretation of federal laws, but whether or not you've established that you were treated any differently or retaliated against. And so the situation, I'll not receive that. My understanding is then go up to C20, which is the notice of unpaid citation. Are you withdrawing that?
Yes, sir.
Okay. All right, then we're dealing with C21, which is starting with page 127.
I'm objecting to that on relevance.
Okay, first in dealing with, I got to get a foundation first because you didn't stipulate to that.
Oh, that's right. We gotta stipulate to that.
Okay, well, do you stipulate to that?
I'll stipulate to foundation and object on relevance.
Okay.
Save us some time.
All right. Then dealing with, I just have to get this thing. So, okay, now, what is the relevance of complaints 21?
Complaints 21 relate to C22 and C26. It establishes that I met with the chair of the university committee, which is a body involved in UWM discipline and oversight.
And so what does that have to do with your case?
I discussed the adverse actions that had occurred that are a product of this complaint with the chair of the UC, and the chair of the UC had Dean Stojkovic augment the executive committee, recognizing that, yes,
Okay,
problems.
and dealing with what my, okay. There's all kinds of different problems and dealing with a situation which could be, which don't have to do with establishing this case, and besides which, this is attempting to get to draw conclusions from a remedial action taken by a respondent, and we can't draw inferences from them because to do so would be to chill employers' remedial actions and saying that, well, I can't do anything to make it better because that might show that that we thought there was some discrimination. So no, by them taking action or doing anything to improve the situation or the response, that I will not take inferences from that it means that there was something discriminatory about the underlying action. It's just that they have concluded that something, that they can do it better. There's few decisions that people make that can't be improved upon, or, it is not something which, for a variety of reasons, are, for policy and evidentiary purposes, you don't want to chill a employer's opportunity to improve the situation by implying that by improving it implies that discrimination had occurred. So I'll not receive that. Okay, then we're dealing with up to 132.
And that one, I'll stipulate to foundation, but object on hearsay.
Okay, and as to the well, my understanding is that it's a letter talking about the response of Chief Flynn's view of what was sent. And the question I have is, what relevance does Chief Flynn's view of the communication have for this case?
Because Chief Flynn is saying that he didn't conflate anything. The pretext that former Dean Stojkovic gave to write the letter, Chief Flynn is saying never occurred. He has no idea what Dean Stojkovic is saying.
Okay, well, I'm dealing with, and that has to do with his state of mind or his response, which still doesn't go to the issue as to whether the action was taken for discriminatory reasons, so I'll not receive it. Again, I am not judging you as an employee or point of things is that a finding that you did something wrong or whatever. That's for somebody else to do. The question is solely on the question as to whether or not that your evidence proves a violation of the Wisconsin Fair Employment Law. Okay, so then next to dealing with the that 136 and who's you got 136?
I do not.
Let me know when you get it.
Yes, sir. Yes, 136. Those are notes that I'm sorry.
Okay, when I was asking a question as to whose notes are those?
My notes.
And those are notes of a meeting with Chief Flynn?
Yes, I took these notes while I was in a meeting with Chief Flynn.
Okay, and what does this have to do with with the issues before you?
Because I asked Chief Flynn if he ever conflated my remunerative consulting with UWM research, and he said he had not, and that Dean Stojkovic had actually conflated it when he gave him an agency research collaboration award for my remunerative consulting work.
Okay,
But
well,
no
dealing with
basis-
but my understanding is that this has to do with Chief Flynn's opinion, which is also, he's not testifying here regarding your dealing with your statements about his statements. This is your statements about his statements about Dean Stojkovic's statements, and it's got a couple levels of hearsay. I won't admit it. Next, in dealing with the with 139, and these are these emails from 2014, and my understanding is that, you know, given the situation, are you are you still Ms. Herzog disputing foundation?
Foundation, hearsay, and relevance.
What is foundation? I mean, I know the things are going, but are you really disputing foundation that these are what they appear to be?
It's very hard for me to tell exactly how these got transmitted, but I'll concede to foundation, but maintain
Okay. All
hearsay
right.
and
So,
relevance.
all right. Now dealing with that, these are, what are these being offered for?
to establish that Dr. Lovell, Dean Stojkovic, attended 2 community listening sessions with Chief Flynn in 2014. These are the listening sessions that UWM is referencing, or Dean Stojkovic is referencing, for the basis for the negative letter he wrote to Chief Flynn.
My understanding, you know, that's disputed in the situation, but you're claiming that these are the basis for them, and um, just a second. What is the number of his letter? I need to refresh my. What's
C13.
C13? Okay.
Is that what you have, Ms. Herzog? No, that can't be C. Oh, C13.
The dean's letter,
Yes,
Yeah.
that's C13. Yes.
thank you.
Okay. Where, and just to check in the situation, I don't see any reference to any listening session.
UWM's position statement, Your Honor.
No, I'm talking about in the letter.
Yes, he said
There is-
you discussed it in public forum, and UWM has argued that the public forum.
Hold on a second, dealing with the matter. Where is there a reference to being discussed in a public forum? It says you have on multiple occasions characterized such partnerships as one between MPD and University of Wisconsin-Milwaukee. But it doesn't refer to any public forum specifically, and it says it refers to just multiple occasions.
And then it states in the next paragraph, this means that at no time is it appropriate for MPD to make any reference. It says this includes statements.
Right, but it doesn't refer to any particular, it doesn't, but where in there is any reference to any such form? I don't see any specific reference to it in the letter.
It's in the position statement. That's how UWM.
No, but I'm just saying the letter itself does not refer to any. So in dealing with, I would, the question, and I think is a different one, and I will not receive it. But my question is dealing with obviously just a completely different one, which is frankly, I think, more helpful to you, Ms. Hessel. And that is that if for 3 years they don't do anything about what happened in 2014, and then you file a complaint and they do, you don't need anything else. I mean, if there's nothing else that happened after the filing a complaint, it looks like it could be retaliatory. So it has nothing. The nature of the retaliation is that clearly that the question as to in dealing with the testimony other ways is that what precipitated, if there is nothing that happened between the between you filing a complaint and this letter, then the respondent will have to find a way to explain why this letter was sent, but it is not needed to have a C-24D to, I think if it is a, if they're what referring to in their description and their testimony and otherwise refers to things that happened before, it's different than after. So we will deal with that situation. So okay. Then in dealing with the, so that's not received. Now we're dealing with the issue regarding the timeline. When did you, and that's, well, just dealing with the situation to go over the audio recording, and since I need to deal with this, how was that recording made?
On my cell phone.
Okay, and um, And this was relating to, and it was on the phone call, so you recorded it.
No, it was a
But the-
meeting in person, Your Honor. We were in
Okay.
person, but I recorded it on my phone.
Okay, and just to check regarding these things, did you say that you were recording it or anything or not?
No, sir.
Okay, and this was in 2000, and you know what the date of that was? Or do you
Um,
remember?
I believe it was May 1st.
And why do you believe it's May 1st?
That's just the date. No, yeah, the date that I'm recalling that we met. I can look it up though if you'd like me to give you a specific
No,
date.
it's going from your memory at this point.
Okay.
Okay, and um, what do you remember? What was the purpose of the meeting?
The IRB investigation.
And what do you remember being discussed at that meeting?
A host of things. It was over an hour long. So it was about, do you want me to tell you what happened during the meeting, Your Honor?
Just as far as you remember, and this is
Yes.
this is with the person who was doing the investigation, right?
Yes. Melissa Spadanuda told me that this investigation, the allegations were ridiculous. She told me that.
Okay, just hold on a second here.
Sorry.
Um, okay, so we have, and what she said about that is what occurred. I just sort of note in the matter that we have. Does this recording involve her making any statements regarding any communications with other people at with the dean?
Yes, she says directly that UWM Legal, Ms. Herzog, Dean Stojkovic's attorney of record, told her to issue me a letter of noncompliance without even meeting with me or discussing it with me.
Okay, so dealing with the situation, but you're saying that there's references to what dealing with that there are references in that to communications with the with counsel, those claims about that. Is there, I mean, obviously in the situation that what was said in the situation, it sounds like, is there any issue regarding foundation of this, Ms. Herzog?
No, actually, I think it's pretty important we hear what was actually said in that recording.
Okay, so you'll stipulate to admission?
I will.
Okay, so then dealing with the matter as in the situation, it would seem like you'd also have to because it involves allegations of communications with you. Okay, so that's admitted. And then dealing with because that was just dealing with the questions regarding these issues with your exhibits. Okay, so back to the timeline. 143. When did you prepare this? Or was this prepared by you?
I prepared it, Your Honor.
And when did you prepare it?
I don't recall the exact date. I prepared it for, this complaint, but I don't recall the exact date. I mean, well, let me take that back, Your Honor. I prepared it after receiving UWM's discovery documents.
Okay. And what is the respondent's position regarding admission of this?
I have no problem with Dr. Hassel testifying to these things and using this to refresh her memory, but I don't believe it's admissible evidence. It's hearsay. It was created long after this case had commenced.
And clearly in the matter we have some dates that went into 2018, so it's clearly not. I will not receive it. Yes, in the matter that there's certain situations, if you that it is not a kind of document that is, it's all based on your memory and stuff, and it's hearsay regarding what occurred. So I won't receive that. Okay, then we are on to complaints 26, the second audio recording, and just a sec regarding complaints 26. What well, by the way, just back to the, one of the things for briefing, you made a variety of claims regarding what the investigator for what you're claiming that she said to you during your meeting. Oh, but then there was not long afterward an issuance of a letter finding validity to the issues. And part of the thing in dealing with it for that reconciled in some manner to the extent that they are relevant. So just to note, but then to complaints 26, this recording, how was this, and who made this?
It was an executive committee meeting that Dean Stojkovic attended. We attended in person and I recorded it using my cell phone.
And what does and this was in January of 2018, clearly after the events in question, and how is it relevant?
Dean Stojkovic informs the executive committee that the chair of the university committee recommended that he augment the executive committee to ensure everybody is being treated fairly, that there were equity issues or fairness issues. I believe fairness was the word used.
Okay, and in dealing with this is talking about the recognizing the remedial actions taken in response to your complaint after the matter regarding the university that you've referred to before, correct?
I didn't understand your question, Your Honor.
It wasn't the best stated. My understanding is we've talked before regarding about what happened after that you made a complaint to the university that there were certain things that happened, and then that this is dealing with that there being a direction to change certain of what occurred previously, right?
No, sir, that's not entirely accurate. I didn't file a formal internal complaint. I met with the chair of the UC and discussed the problems that were occurring.
Okay, I mean, all right, I was referring to that as a complaint.
Oh, I'm sorry.
But other than that, there were certain changes to what occurred that done by the university in response to your verbal complaint, correct?
Yes.
Okay, and what's the response position about this?
Again, I don't see the relevance to the questions at issue. This is the dean saying, hey, people have been complaining, so I think we're going to try to make things better going forward. That's not admission. That doesn't go to motivations for any prior actions. That I just don't see the relevance.
And I will agree, I will not receive that either. It's again, it's dealing with this. We don't, it would be a terrible policy regarding the department and other things to chill people's efforts to do things better in response to complaints, because every time they do, there'd be inference that they would be admitting a violation. I won't go there, so that's not admitted. Then we're to C29, which is the 154. And okay, so my understanding, the key thing in this situation regarding the use, okay, that this is I'm trying to see somewhere on the document whether there's some date of when this was done. Is there some in dealing with this, what is this from?
I'm trying to get to the document, Your Honor. I'm sorry, just one
Okay.
second, please. Oh. So this is from the, if I'm on the right.
It says use of force reports. 154.
Yes, so it's from the use of force reports.
C29. Well, there's no C29 on it because you stopped marking the things, but it 154 has it's the center of the use of force reports, it says.
Yes, so this was taken from the Fire and Police Commission website. You can see that at the top. And so it documents that Dr. Brandel had an ongoing remunerative consulting arrangement with the Fire and Police Commission. Dr. Brandel is a comparator.
But when was this taken off? That it's got to be after.
I took it off when you gave me
2018.
You gave me instructions after we had the hearing that I could look for evidence that, you know, Dr. Brandel's remunerative consulting work was associated with UWM in a public forum, and that I could submit that evidence to you for use in establishing that.
Okay, so this was printed off in 2022.
Yes.
So it's the date. So the date in the bottom, this was printed in April of 22.
Yes, it was after our hearing.
Okay, and what's the response position regarding this, and this just being offered to show that this was in their website at that time?
So I have two issues with it. One is that I'm not certain what date it was actually published on, but my other issue is that if it is being used as a comparator, the comparator would be a statement that the Fire and Police Commission is collaborating with the University of Wisconsin-Milwaukee, not is collaborating with this individual who works at the University of Wisconsin-Milwaukee. So it's not an appropriate comparator.
That's right. It says that he is a so for a couple reasons I won't receive it. It does simply say that, you know, what his job is, not that it was a UW Milwaukee report. So, and we also have the different kind of things, but I don't, that doesn't appear to be appropriate evidence in this. And then I think the discovery responses are, my understanding is that you're saving those for impeachment, but are not asking for admission at this point. Is that right?
Are you asking me? Your Honor?
Cecil? Yeah.
Um,
Are you asking for those to be admitted?
yes, you told me that I could admit them, so I did.
Well, no, I'm the one that decides whether to admit them or not.
At the end of the hearing, you allowed me to admit a few documents that you allowed me to do.
No, I allowed you to supplement your list with putting the additions regarding admission is being done now. That's not admission. That I haven't done that. So you're asking for the to be able. That's yeah. It's confusing terminology. Okay, so in dealing with does the respondent, I think the respondent indicated they had objection to the receipt of your discovery responses. Is that right?
I'm fine with the interrogatories. The exhibits are all redundant, I believe, with,
Oh, it's the redundancy issue.
yeah.
I believe it's just, I don't think that I included the exhibits. I just included what you wrote.
Am I looking at this incorrectly?
So I didn't include the documents that you produced.
Okay, she's just looking at it a second and dealing with the.
So that's, sorry, I'm scrolling down to the right thing.